Before we begin this panel, I would like to invite Vladimir Maric, the Director of Intellectual Property Office of the Republic of Serbia, to officially open the AI intellectual property track. So, Vladimir.
Thank you. Okay. So, ladies and gentlemen, I hope you can hear me well. On behalf of the Intellectual Property Office of the Republic of Serbia and myself, please allow me to thank you for the invitation and for the opportunity to address you at this important event. It is important because creative industries in Serbia make up for about 5.5% of gross domestic product, with over 100,000 mostly young people working in this sector. Video games produced in Serbia, for example, in the course of 2022, were downloaded and paid more than 100 million times globally. Serbia currently has 140 companies engaged in the development of video games, of which 51% of companies develop their own intellectual property, create their own original video games. The topic that gathers us here is currently the most relevant sociological and cultural issue of the modern world. Today, artificial intelligence is an inexhaustible source of numerous interesting discussions about the advantages and disadvantages that this new technology brings to the modern world. Predictions of its impact range from one extreme to the other, from an opinion that it is an invention that represents a qualitative step forward in our evolutionary development, to an idea that it will be the death of us. This is not the first time that an invention would change the world as we know it. So please let me read a quote from 1471 to illustrate. So it's a 15th century. Humanities owe their powerful light to that new type of booksellers who came out of Germany like Trojan horse to spread to all parts of civilized world. It is said that Johann, known as a Gutenberg, who was the first to invent the art of printing, lived somewhere in the vicinity of Mainz. Thanks to that art, and with the help of the metal letters, without the use of reeds and hills, books are made quickly, accurately, and beautifully. Gutenberg's invention gave us letters by means of which everything that is said and everything that is taught can be immediately written down, transcribed, and left to posterity. End of the quote. But one thing is less known, namely it was already seen that book printing is an activity that requires large investments and a complex organizational effort. It is a very capitalistic activity. Gutenberg didn't die a rich man, and throughout his life he was on the verge of bankruptcy several times. In short, the printing houses would have died and disappeared had it not been for enterprising merchants who saw a profit in it. I believe that even artificial intelligence wouldn't have a different fate if huge financial resources were not invested in it and are still being invested. I believe to ignore the supervision of artificial intelligence development is not the way to promising a bright future for a nation. As a society, we will have to invest in it more and more. So let me emphasize at this point that the Republic of Serbia has established the Institute for Artificial Intelligence Research and Development, and that was the great step in the right direction. The undoubtedly enormous importance of artificial intelligence for the modern world is due to its widespread and massive application. This makes me remember a small anecdote. I was in a car museum in Torino, Italy. And one of the exhibits was Fiat 500. It stood in a prominent spot, an obvious place of honor. I wonder why, between all the Ferraris, Lamborghinis, Alfa Romeos, and so on. I was then told that it is the most important Italian car of all time. Its enormous popularity is due to ideal ratio between price and quality. It was a good car that anyone who worked and with a steady income could afford. That's how the car changed the Italian society and ours, at the time Yugoslav society, because the working class could travel more, socialize, have more time for leisure and entertainment. That car has somewhat changed the way we live. A similar thing is happening today with the artificial intelligence, which is slowly but unstoppably becoming a part of every aspect of our life and work, just as was the case with the internet in the 90s. I have read that the evolution has neither a plan nor an order. It is non-linear and, contrary to popular opinion, does not guarantee progress. This is a common misconception. Evolution is spontaneous, somewhat chaotic process which ends with the establishment of the layout that is most stable for the given set of circumstances at the given moment for the given species. The question is, will artistic creativity, which in the traditional sense was reserved for humans, slowly pass into the hands of machines managed by the artificial intelligence? Or more precisely, will we admit that the machines can be authors? CISAC launched an initiative to legally regulate this issue, first of all by stipulating that machines may only be a tool used by the people, one that helps them to create, but the tool that cannot be a creator. At the root of this idea is the same philosophy that was once expressed by the science fiction writer Isaac Asimov when talking about the principles of robotics. The first principle of robotics is no robot can harm a human being. And it seems to me that the same fear is at the root of what the authors are looking for today. How can we prevent artificial intelligence hurting us? For example, by leaving millions of creative people without job and income. To be recognized as an author is currently reserved by law only for humans. Machines and animals can't be authors, and I'm strongly in favor of that, even though I don't know what the future will bring. In the IP Office of Serbia, artificial intelligence is here to help us improve the efficiency and quality of our services, and its potential is huge. Currently, we use the WIPO Goods and Service Assistant and the WIPO Patent OCR proofreading platform. Moreover, in the scope of EPO Patent Machine Translation Project, IP Office of Serbia provided corpora of full-text patent specification document pairs, Serbian and English, for specific machine translation learning purposes. All of them are based on artificial intelligence. Chatbots have a great potential for us too. We don't use it at the moment, but we will certainly implement them sooner or later. Instead of today's officials explaining to the parties the importance of patent or trademark protection, how to pay the fee, how to use our online system for filing applications, and so on, the already mentioned chatbots will one day do that. Of course, we must not forget that artificial intelligence is not an end in itself, but it represents only a means, one of the answers to the questions that is troubling us. In this sense, it should be observed and used soberly and thoughtfully, always asking ourselves whether it is the best solution at a given moment for the given circumstances. Ultimately, how successful the artificial intelligence will be for us depends on the quality of the data we supply it with. That's where we get to the witty garbage in, garbage out saying. How good that tool will be for us depends on that. Data input quality is crucial. And finally, I would like to end this introductory word by referring on one example from the world of literature, which has nothing to do with the artificial intelligence, but has to do with the human nature, and it is connected with this subject matter. In the novel called Notes from the Dead House, a Russian writer, Dostoevsky, describes his last moments in prison. He describes a scene when the shackles are being removed from his legs with the help of the hammer, shackles that he had worn for years. When they fell to the ground, he hears their clatter and instantly says he is surprised they were ever there, ever there. This scene has a deep symbolism. On the one hand, mankind can get accustomed easily to the better things, so they will easily and naturally accept all the benefits that artificial intelligence will bring them. On the other hand, the state of not being free is something with which a person fundamentally never comes to terms. Artificial intelligence today is still in the hands of man, and I believe and hope that man will be wise enough to never allow the roles to be reversed. So I thank you for your attention.
Just a certificate of appreciation for you. Here.
All right, thank you so much.
Thank you for the opening talk. And now I will ask all the speakers in this segment to come to the stage. First, they will give, each of them will give a talk, and then we will have a panel discussion in the end. So first, it's Nikola Kliska, Andrea Radonjanin, Ksenia Gygax, Gaetano Dimita, and the moderator will be Djordje Krivokapic.
I have a hard assignment now because running a discussion after these well-structured presentations does not have many open questions, but I hope the audience will have some of them. However, I wanted to structure the questions on 5 tracks and 5 rounds. First the questions regarding training data, then to talk about output treatments and questions in that respect, then touch a bit in terms of services as a very important factor regarding generative AI, and then go to policy considerations and eventually impact on game development process and gaming organizations and, let's say, labor relations in that respect. So, my first question is for the audience. Does anyone has a question in the area of training data? No, not at the moment. I have one. I have many, but I would just ask a couple of very practical questions. So maybe some of you can provide some advices in respect to them. So, what are the limitations and legal ability regarding scraping data today on the web? Because that's something what we see as a very common practice, but they're not like real and clear rules in that respect. The second question is, do you have any experience and advice on buying and selling bulk data and copyrighted collections for training purposes especially, and developing and creating licenses in that respect? And for developers, on the other side, working with the training data sets, what are really transparency obligations at this moment? What they need to disclose? And if we are on the other side, if we have assumption that maybe somebody used our work for training purposes, is there any mechanism how we can find out about that? So I put 4 questions now. Which go through all the things you already talked about, but maybe some of you can answer some of it if you have any experience in that respect, because they're all open-ended, so we know that there are no clear answers at the moment. Anybody brave enough to touch?
Just a short note about buying data sets. We had a couple of cases, but they were quite simple. So the parties agreed initially, so we just drafted a simple contract, and we didn't see any significant issue in that transaction.
So mainly it's only transfer of the license for training over these copyrighted collections, and then everything else is again based on trust and maybe some additional transparency rules where seller can put these transparency rules into the contract to implement what is lacked on the other side.
No, I don't have the answer, but I share some of your question, because for instance, now that there is case law, some companies have been asked by court to provide the data set that they use in order to, and on top of the one that are known, that normally have a license regime in place, they're also pretty careful in showing that all the data they include, they're being authorized. So they actually use, you know, the vetting on, we're fine, this is all in the public domain, we're fine, this is all obtained in this particular way. There are book 1, book 2, and book 3 that no one knows where the data was coming from. And these data sets are part of a lot of the bulk data that has been licensed worldwide. And I find it curious because I mean there are I think 2 or 3 companies that work on bulk data, and they all share the same issue. And your question on transparency, I don't know if there is, I mean, to what extent there is an obligation of telling where the data is coming from, because I think that at this point we have no idea where the data is coming from, and that links to there is a lot of bad data that is part of this data set, and then of course the output is terrible, but we cannot trace it back, which is the bad data to filter out. And of course you cannot start from scratch. I mean, you cannot restart. No one in his sane mind will start the database from scratch, but I think I don't know how this problem is solvable from a technical perspective. From a legal perspective, lawsuits after lawsuits and trying to remove.
It's already been fed, right? Yeah. So if it's corrupted, it's corrupted. But just coming back to your first question, and I think you mentioned that as well, I think the key problem is that we don't really understand how it works. And I've tried asking people to explain that to me. So we don't know, you know, the reproduction part, if it's happening, is it permanent, is it just temporary, and so on. And I think this is something that we're hoping the courts are going to answer for us. Maybe they will, you know, have enough technical expertise to explain this to them, so that we actually know in copyright terms what's happening with the scraping of data. And I think this is the key problem for us, but it also means that we need to employ a more interdisciplinary approach to understand all these aspects, because we as lawyers love to only think about the legal questions, but we don't technically understand the process to sufficient degree now to understand exactly what's happening. And that's why we have so many questions and not that many answers at the moment, as you said.
And if I may, just to add, Djordje, I very much liked your distinction of AI into 3 elements. That's how we see it at WIPO as well. So basically input, the core AI, and then output. So in the input side is data, which is of course the core of it. And I would like to address you to one of our WIPO conversations that was focused on data, because it raises many, many questions, and we don't have much time to discuss this, but already we provided a forum to give you a bit of an idea of the legal questions and the practical issues related to data. So if you're interested, you can look. This is a 2-day event with experts from all parts of the world, which focuses on data. And then we're going to have a practical publication for policymakers and innovators that will raise some of the questions which, Djordje, you have just posed to us, and which we might not have answers at the moment. Again, there are some scenarios that we can foresee, so watch the space, and there will be a big announcement also in terms of question of data as a big and important element of ChatGPT and all those generative AI technologies. So there will be a big event coming up next year, so no spoiler anymore, so please watch the space. Thank you.
Thank you. And just one more question. Nikola was talking about data auditing, and we all can envision, understand what it is, but do we have any practical guidelines, good practices, or some concrete advice if we are really constructing a training data set? Like, what would be the real steps of data auditing in this respect, and like any tools we can really use to be at least not 100% sure, but at least sure that we are doing the right thing in data auditing segment?
Well, for now I can say I have only bad practices. So each time we had an issue like that, we engaged external expert who is an IT guy or usually professor at university. But they were not that much into that particular field, so they were not able to provide the final result to us. Their reports always ended up with the conclusion that they were not able to conclude what happened. And that happened in a couple of transactions, and that happened in a couple of court cases, which were not related to AI, but mostly to coding and software engineering.
Okay, that's very satisfying answer for me. Then we discovered what is missing in the field and what is really needed. So now I'll go to the second area of discussion, which related to treatment of the output in relation to copyright. And is anybody from the audience have any question on that layer? For me, again, the only question is, because it's obvious that all the creators today are really under pressure to use AI tools. So, and we talk on every conference in every sector, what's going to be with educators. AI will not replace the educators, but educators using AI will replace the educators not using AI, and then we apply that to lawyers and to designers and so on. So we definitely are pushing everyone to really accept these new tools and improve their processes and really digitally transform their production process in many, many ways. So is there any good practice when we work with AI tools? Because we worked with AI tools before. They're embedded into as the features from Photoshop and Corel to Illustrator and so on, to all apps we are using. What would be really good practices when we use AI tools to be sure that our human involvement is dominant one? Maybe about archiving or creating the process in a certain way.
Yeah, well, speaking from a lawyerish perspective, and I'm sorry Maria is not here to share with us, we, for example, already used AI to produce, she did it, to produce a standardized employment agreement, for example. And so she fed it with her own data, all the clauses from different versions of employment agreements, white collar, blue collar, so on, so different multiple choices. And then what you also need to do on the output side is you need to check all the data. You can't just accept, as Gaetano said, AI is often hallucinating, making up stuff. And we all know the case of this US lawyer who filed a submission without checking and I think you mentioned your students do the same sometimes. So AI makes up stuff if she can't find it. So you need to check also the output very, very carefully, and maybe even do some tweaks, additions, so on, to ensure that the end product really corresponds to what you originally had in your mind.
There are a couple of basic suggestions. They're not based on case law. I mean, my independent analysis is so probably wrong, but there are basic things that I think would increase the chances. Having a draft already, having a sketch somewhere, even in Paint, something. No, I mean, actually, I don't know if you've ever seen the court case involving bunging and publishing. The entire IP was based on a sketch on a napkin. Actually, the sketch on the napkin can be, your key to success, if then is what is starting everything. And keep the human involvement. Another thing that is based on what I can see happening in a couple of cases pending in the US, avoid prompt that involve someone else. So having, in the style is the borderline, especially if you go into text, but if you're doing a video, avoid doing something in Harry Potter style or in Hogwarts or in Star Wars style, because you will be asked for the prompts. And actually, if a court would look at it and say, he was trying to create something that is similar, but not too similar. So it might not be copyright infringement, could be unfair competition. You might get in fields you don't want to be. So maintain it yours, your intellectual creation. Data selection, of course, unless you're not, you will have to render it. Put the human touch there. Ideally, use your own artworks for feeding the algorithm. Of course, it's a little bit risky, because if you're using third-party tools, then you're making even the other people output better, and you don't want to do that. But in an ideal world, having your own tool fed with your own works. This is literally what law firms are doing at the moment. They are creating their own data set, so they can be sure. At least they can feel responsible. If we did a mistake, it was our mistake, not someone else.
I have a question, if that's okay.
Yeah, please.
Hello, regarding the question you asked. So now Adobe has like Photoshop beta and InDesign beta and everything. So is the copyright basically on the prompt that we used, or the image generation, or is it just on the output of the image that's there? Because Adobe will be like have the copyright because it's their tool, right? What's the allegation there?
I'm trying to think how to keep it short, because it is an amazing question, and that is a 35,000 words article to be written on that point. It is a very important question whether or not you might get copyright on the prompt. The thing is, you're not going to get copyright on the prompt, because of course that would say, design me 40 years old that looks like a wizard. That's not going to be protected by copyright. But even the expression of the sentence, that's not original enough. But the way in which, by prompts, you are actually influencing the output could eventually, the entire set, be creative enough to guarantee you copyright protection. Of course, depending on the jurisdiction, depending on a lot of depends.
Yeah, but
however, will be a weak copyright, because that's where I get stuck, and I ask help to the others IP lawyers here. Because at that point, you have originality. You might be the copyright author of that particular AI-enhanced image, but that's not going to protect you from someone else using actually a very similar prompts that come up with the very same image. Because your creative input is actually, the creativity part is actually asking the machine to change and change and change. If someone does it independently without copy and pasting your prompt, might be an independent copyright work, and that doesn't help you, that you want to commercially exploit your own work. So, I don't know.
But no, I think can it be copyrighted by like Adobe because it's their tool, their everything, yeah. Because if we like earn a lot of money and they like use their tool.
The pre-generative AI tools, they're not creative. You are inputting, you are modifying images that you are providing, you're choosing all the images. The difference with generative AI is that they are doing a lot of things that you're not anticipating. There is sorry to go back in history, but there are a lot of artists that, for instance, Michelangelo didn't paint himself. He had 500 people painting the Sistine Chapel, and then he would arrive every evening, make a couple of changes, or say, okay, you're fired, I'm going to repaint that tomorroh. But that doesn't mean that the work wasn't Michelangelo. It is the same in physical and human form. We have a lot of experiences that. This is how we've been working for centuries. Just that the AI doesn't do what you want to do. You're actually suggesting them. You're prompting. And then based on non-creative choices, because it's just probability checks, even for is going to give things what is more probable that you meant. And that's, of course, is not a creativity standard. That was a very tough question. I don't know if I have to thank you or not about that, but is it?
Thank you for these answers. I'll just conclude that documenting the process would be really important. When I think about the guidelines, what is this essential element regarding human involvement in the process comparing to AI is really how do you reduce the autonomy of the system. If you establish the clear goal at the beginning, if you know what you want to create, putting a sketch, what you are looking for, and then you use AI tools to do the process faster, more effective, cheaper, and so on, then you are fully in control. But if you know that you need something what looks good, but you don't know what it's going to be, then definitely you are not in control. The autonomy of AI system is prevailing in that situation.
And we also have now proof that this advice is very sound, because not that the Copyright Office of the US should decide for the future of every one of us. They did it a couple of times in the past. I mean, we all followed what they did. But at the moment, for instance, for a very interesting project on a comic book, designed by the human author, the story script was designed by the human author, but she just used Midjourney to create the single scene. And that took ages because, of course, first the creating of the avatar, all this is. The Copyright Office replied that while she has copyright on the text and on the script of the comic book, the actual comic book is not protectable, it's not registrable. There are these two different layers in the US. We know it's not registrable, but there is still common law copyright. There are other layers of copyright beyond the registration that might be still applicable. But this is a little bit of very risky for the investment, because you might end up saying, you know what, the two sentences of the name of the character they're designing are, of course, you know, your creation. But you know, the entire environment that you created around, that is like the main level of your video game, that's not protected. Anyone else can take it, just changing the main avatar.
So basically just the idea and the text can be copyrighted to him, right?
No, the idea never. The expression is only, okay, I'm gonna make it correct but nonsensical. Only the original expression that is dictated by human control and creativity will be protected. Whatever that means, but the sentence is correct.
So artwork will not be like, copyrighted. If it's used like Midjourney, I know my colleagues did something similar like that.
Now, if you go on Midjourney and say, design me a character, you know, a female character in their 30s wearing an armor, it's very difficult that the result is going to be protected by copyright, even if you create 500 of them and then you select the one you like. The selection is not part of the creative process.
Yeah, but prompt generation is his idea, right? His choices and everything, basically.
Yes, but it's going to be a case-to-case analysis, because if you have a painter, so always easier for IP lawyers to go, you know, with precedent that we are familiar with. If you tell a painter, paint me something without giving any specifics, and then you go back and say, you know, I don't like that character, change this, change that, and that, the copyright is still with the painter, not for you. But if you go to a painter and you give a very detailed instruction on what you want them to paint, in that case, you are the author of the painting, not the person that actually paints it. And I think that the similar analysis will be done with generative AI. It's just more complex to prove. And actually, basically, your suggestion is the only one. Keep track of everything.
Yeah, I have one question about the picture, like for the baboon. So basically, the one that you have for a baboon, like selfie, that did. So if, for example, the photograph has the copyright, right? And the person that like switched the trigger. So basically, if I saw a picture that is like copyrighted and I took a photo of it, am I?
You're infringing copyright, yes.
Yeah. So
quick answer, yes. But if you take a different photograph of the same subject, maybe not. But I'm using maybe because even that might not be that straightforward.
Thank you.
Hi, thank you for the beautiful presentation. My question is more on the technical part. So I currently work as a machine learning engineer, and somehow I do it, training data. And I've had to do, work on a research at some point, and I saw in your presentation, you were like, for the EU, right, you're allowed to get this training data, right? So, and the purpose of research is that we make, innovations, and then we make this open source, right? So individuals, organizations can use these models that we make open source, right? And then it's still like you're literally giving them the data sets, because if you're giving me access to open source models, I can take that open source model and then fine tune it on my own industry specific data. So is that not sort of bypassing the whole idea where organizations have to get licensed to use particular data? Because if I'm using research from an organization, let me say academic, right? So I'm using their open source model, and then I'm using it for my own business case. But then I don't have direct access to get this data unless I have license. Is that not sort of bypassing that?
I'm not sure I understood the question. Can I answer it anyway? No, I mean, the 2 points. Yes, the text and data mining in Europe, but I don't think everyone implemented it yet. No, but the thing is, there are two ones. You're referring to the one for research purpose, the non-commercial one. The non-commercial one, I don't think you can license. I mean, it's your personal. I'm asking. I mean, I'm not 100%. I mean, because otherwise, if you license it externally yourself, that might constitute a commercial use of the, even if it's an open source license. Because remember, an open source license is still a copyright license. Just as a copyright license that on which you attach the possibility to access the underlying data or the source code of the software, in exchange of, depending on the kind of license, the fact that whatever derivative works is created has to be distributed with the same license. So you're actually creating a chain of people that are linked to whatever you want them to be linked with. So there is one thing is when you obtain the data, they might be covered from limitation exception, but that limitation exception may fail if then you change the reasoning for which you're using that particular data.
Okay, I have a question there. So let's assume we go under the exception as a research institution, publicly funded, to create a model. And now we have the model. And then what does it mean non-commercial purpose? Like, because also models have many levels and characteristics. So, and then that model can be used for commercial purposes. And we can provide model open source to everyone on one level, but if we provide more data again and more insights into the model to the others who can then have competitive advantage, is it non-commercial, commercial? What is really how do we, at the end of the chain, really make a model non-commercial?
I'm holding the mic because I feel like no one wants to volunteer for this question. Okay, you're asking a fundamental question, and I have so many doubts about those two exceptions, because even the way they evolved and when they got split was probably not the best example of EU legislation in general. I think I said it in a very, that was very elegant. It creates a question. For instance, my first question has always been, why text and data? Isn't text also data? I mean, why are we spelling out this text? Does it mean images are not covered, or they're, what kind of data? Because I mean, data has different meanings in the data scientist world and in the IP world, and I'm pretty sure there's a different meanings for regulator and politician. What is this data? What is big data? I mean, I don't know. So first of all, what is the subject matter of the limitation exception? The second one, the reason there was so much strong discussion on text and data mining, it was because while in the US the approach has been fair use, you don't need a separate license. So within your license to access a work, you can text and data mine it. You can mine it. You can scrap it because it's part of the region. You don't need a separate license. While in Europe, our approach was, and that's where my question on reproduction is, you need a license to read and a license to scrape. Like they are two different activities. They always felt a little bit wrong to me, because if I do have, this is a silly example coming from a colleague of mine that is a little, it's from a different generation. But he was asking me, isn't it the same of asking you firstly to buy the book and then a license to make a copy in your retina? That is the physical parallel. But this is the way we went in the EU. And I say we went in the EU, even if now I live in the UK, that is outside of the EU. And that's called for the text and data mining exception, because of course you cannot develop anything if you need for everything, even for testing, for research, as an academic institution, you cannot survive if you have to get a commercial license for everything. So they designed the text limitation. Then your question came abroad and say, but wait a second, what if you train the data set? Then you have this amazing purely trained data set. Can you commercialize that? And this is the oddity. They went, no, we're going to have another limitation exception that is for commercial use. And on the question of commercial use, in my PhD thesis, I have a footnote that says, this goes beyond the scope of my thesis. Define non-commercial use. Because it's really, you're right, it's really difficult, and plus the way the business work, there are a lot of uses that today we think are non-commercial, they might become extremely commercially viable, and uses that we consider today as commercial, that they're going to disappear, and they're going to be basic transfer of data, or basic training of data, or even open access database for testing, for instance. Testing and checking on parallel database what the algorithm does, all the studies done on understanding the black box. You need two independent databases, and that at the moment is commercial. Might be non-commercial in the future when we use it for I don't want to get there, but I mean there is a lot of things that are coming our ways.
Thank you for answering these hard questions. So the third area of topics is related to terms of services. I don't think there are any questions on that side, and I won't pose any question, but maybe try to add some on the discussions we already had. Is that, like, at this stage we have business models developed in a way that some tools are free, some tools are paid, but not too much paid at the moment, because we pay them mainly through our immaterial work on these platforms, doing all the corrections and feeding the data sets, but there we change. And that's one thing which we need to really pay attention to, how the contractual terms and transactional rationale will change over time, and not to base our work and our business models on the current state of terms of services. And terms and conditions, whatever. Anyway, I want to point out that, like, the fact that AI providers are transferring us ownership, as already explained, it's not ownership in any real sense, because we cannot really control these immaterial objects because we do not have any exclusivity right over them. It's only the liability about the output and breaching any right. So breaching potentially also copyright if there is any similarity on the level of the structure, but also maybe personality rights, data protection rights, non-discrimination rights, and so on. And really, when using anything what is output of AI, we need to take deep analysis, because we are the responsible one. And that's the only advice I can provide there. On the other hand, everything related to the training data going back is responsibility of AI provider. It's still, and it's not our responsibility. I don't see how it can be. So that's on terms and services. And then we have the last two questions, and I'll put them together if there are no more questions in the audience. Is there no? So first, on one side, we have this huge change on the process because we have new tools able to really deliver solutions which were previously delivered by humans, and that is changing organizations, processes, the roles of humans within the organizations, and so on. And on the other hand, we have all these policy considerations which are related to gaps the copyright has in this area, but also gaps related to database protection and maybe some solutions that AI regulation will put on the ground. So this is like one last big question, like, although we talked a bit about that, but what is really expected to happen in next period, short term and long term? Do we expect any international consensus on some of these issues? Or we will be able to see competition between the jurisdictions, how to adapt the rules in order to enable innovation and AI development and win the war, and how the history of IP wars between East and West Hemisphere will impact that? The simple last question.
It sounds like almost a philosophical question, but I will try, since it relates to international rules and policy mechanisms, maybe I can try a little bit. And if I took on behalf of WIPO, what we see, of course, and we as a member-driven organization, we see where the appetite of the member states is and how we can respond to it in the best way. So what we've seen and what we probably discussed today, what my colleagues have mentioned in terms of case law, we see that generally, and I can't speak, of course, on behalf of all member states, and I probably shouldn't do that because I don't have this mandate, but what we see in terms of like case law and different consultations around the world happening around AI is that member states are generally, there's a bit of an agreement that the current rules and regulations are flexible enough. So in many consultations, countries looked into different examples of technologies and how IP could actually stretch itself and cover those types of technologies, although we know that it was created with a human around it, and this is what proves again in many cases around the world. And so in that sense, we're observing very carefully, and as I said, there are a lot of consultations, but probably one of the main outcomes there is that there's a flexibility, and actually the IP law was designed to cover these technologies, and one of them was photography, then became internet, and now AI is one of them. Of course, another aspect is that the AI technology develops very rapidly, so no one would think that ChatGPT would come so fast, because this technology is sort of revolutionary, although it comes from traditional AI, but still, we're looking very closely. But again, it would be interesting to see how when the input of the human will decrease to that degree where it's actually where AI is taking over all aspects of the creative process. So we're not yet there, although I have to say we are thinking about it, and WIPO is preparing a paper which actually deals with the IP scenarios in relation to AI. So what are the policy considerations? Djordje, you mentioned some sort of harmonization or maybe a treaty or something in this space. Of course, it's a little bit difficult, and those who are familiar with WIPO know that, of course, it's a complicated procedure, and we need member states to agree to come together to find those regulations and to have them implemented. So in the current context, of course, it's a little bit difficult. So we are looking into maybe more flexible solutions. And again, member states are very active on that space, and there are a lot of consultations and processes. So watching it very close. I hope I answered your question in the way I could.
Yeah, I agree. I don't think we will have an international agreement on this. And also, I mean, when you look at IP law, it's not harmonized across the globe. And one of the reasons for that is what you mentioned. The legal tradition behind IP law is different in common law countries and civil law countries. So if you look at France and this romantic notion of the author as this divine creature, and then you have the common law approach, which is a more commercial, let's say, one. So we've been trying to harmonize IP law, but we didn't achieve complete harmonization, and I don't think this is going to be the case where we achieve such harmonization. And already now we see a very fragmented approach. So something is allowed in a certain country, in another country it's allowed but with some exceptions, and in a third country it might be complete infringement. So that might, as you said, lead us to certain jurisdictions which are going to be much more competitive. And I think developers are going to be looking at US probably for now, because it seems like it's going to be easier to train the models there for now. But yeah, if I agree with you, if WIPO doesn't feel like there is at this moment room for some international treaty or agreement or whatever, it's probably a premature question. And I don't expect any dramatic changes in IP law as such for now. But yeah, let's see on the output side. That's what actually really I'm curious about. If we're going to do nothing, or we're going to try working on a sui generis model. That's going to be interesting to see. Because maybe, you know, countries will feel that we need to do something, and maybe the pressure from the industry is going to be big as well, because more and more industries are going to rely on generative
especially
AI.
Because now there's every single country wants to be the best country where to develop AI, but they have no idea how to do that.
Okay, so I would like to conclude this panel now. I'm really proud that we really provided state of the art in the area of IP, AI, and gaming at this panel, and I'm so thankful to all the panelists which contributed with this tremendous expertise. And it's lunchtime, so we have to close. So thank you so much.